To introduce myself, my name is Chris Esseltine. I'm a healthcare attorney, and I joined the firm back in October. And I'll give you just a brief background about me and my experience, and then we'll jump into the fascinating world of anti-kickback. I started my career at PhRMA, which was the trade association that represents the pharmaceutical industry. I did mainly compliance issues, all kinds of healthcare issues touching the pharmaceutical industry, fraud and abuse, and Medicare, Medicaid reimbursement, and FDA issues. And I went from there to Arent Fox in Washington, D.C. in their healthcare practice. And there I got a great, broad experience with all kinds of different providers in areas such as, well, let's say providers like hospitals, pharmaceutical companies, device manufacturers, hospice, home health care, skilled nursing facility, physician practices, pharmacy benefit managers, just a wide variety, and it was great. Loved it, and I touched nearly every healthcare issue that a healthcare attorney could touch. So, and then from there, I went out on my own and was an individual. Started my own consulting company, and the last big project I worked on was for a billion-dollar health network. They owned hospitals, physician practices, clinics, SNFs, that kind of thing. And while there, I was contacted by Holland & Hart, who expressed interest in having me come. And I have to say, it's the best organization that I've ever worked for as an attorney. So happy to be here and happy to be putting on this webinar. And even though I can't talk to you individually, happy to meet all of you and to be able to give you a little insight into the anti-kickback statute. So hopefully all of you have pulled up the slides, and we'll just get started to the second slide here. And I've got to ask my IT helper to figure out why this is not, let's see here, why it's not advancing. Right and left arrow on keyboard. Oh, there you go. Thank you, Luke. Okay. And that's not doing it either. Apologize, everybody. These technical difficulties happen from time to time. It worked yesterday when we did a test run. There we go. Okay, thank you. All right, so today we're going to cover the federal anti-kickback statute. We're going to talk about prohibitions, in other words, what you're not allowed to do. We'll talk about penalties, which happen when you do what you're not supposed to do, and then we'll talk about safe harbors, which are basically exceptions to the rule. I'm doing this, it's violating the rule, but the law says I can get away with it because of these circumstances. We're going to apply the anti-kickback statute to common situations that you as clients might face and teach you a little bit about how to respond to potential problems. If you think you have a problem, if you know you have a problem, if the government sends you a nice letter and a subpoena, and that's a pretty good indication you have a problem. So what to do in those situations, and then we're going to talk about some things you can do proactively to make sure you don't run afoul of this law. As far as questions go, you're more than welcome to send them in to this webinar through the chat feature, but I'm not going to answer questions at the end. What I'd rather do is look at the questions individually, and then I'll email you responses. Okay. There are some written materials that we have, PowerPoint slides obviously, and then you can see the following references that you can find on the web very easily for the various regulations and other supplements that might help you understand this law much better. This presentation is being recorded currently, and you can download it at that address. It's our health law blog at the firm. Or you can email me directly, and my email is right down here. So this is what the program today will do, and I'm going to tell you what it doesn't do. The program provides an overview, just an overview of the relevant law. These are tricky regulatory waters to navigate, and there's a lot of gray area in healthcare law. Even though the statute is fairly clear, that's just the way it happens. And so we're not going to get into nitty-gritty and specifics, but we'll give you an overview and a fairly comprehensive overview. We want you to read the law too. We want you to read the regulations, the advisory opinions, and all the other things. And not because we're trying to sell you, but it is always the best course of action if you have questions beyond that you consult someone who's expert in it, especially when the facts are tricky and your situation might be specific to you. One of the things that we find in healthcare law is you can't just look at one law in a vacuum, because if you've done something to violate one law, chances are you've done something to violate other laws as well. So oftentimes when there's an anti-kickback issue, there's also a Stark issue. And a Stark law, for those of you who don't know, is an anti-referral law. The civil monetary penalties law, that's a fun one. The feds throw that in to basically enforce what they can't enforce through other laws. And then there are always state laws that are specific to your particular state that you need to look at, even if you don't think you've violated any federal laws. Now, what the program today does not do, it does not establish an attorney-client relationship, and it does not constitute giving legal advice. I'm not giving you legal advice, I'm just giving you an overview of the law that is available to the common person. All right, having said that and been the consummate lawyer now, let's get into the anti-kickback statute. So this is what it does. It prohibits knowingly and willfully soliciting, receiving, offering, or paying any remuneration. Now that's a big mouthful. Soliciting, receiving, offering, or paying. So even if you make a solicitation for a kickback, even if the kickback isn't paid, then you violated the statute. So any remuneration, directly or indirectly, overtly or covertly, in cash or kind. In other words, it can be something other than money. And anything you do in this arena for any person to induce referrals, to get them to give you patient referrals for items or services for which payment may be made in whole or in part under a federal health care program. So that's a big fancy way of saying that if you give something to somebody so that they will send referrals your way, and those referrals are paid for by a federal health care program, Medicare, Medicaid, anything, then you're in a lot of trouble, unless it fits within some kind of exception or what we call a safe harbor. And we'll talk about those a little later. Now, people say, well, yeah, we talked about referrals, and part of this little arrangement I made with this other person, you know, it involves referrals, but listen, that's not the real reason we're doing it. That's not the main purpose for doing it. And the feds say it doesn't matter if you've if just one of the purposes of this little remuneration arrangement you've made is to induce or reward referrals, then you violated the anti-kickback statute. Doesn't matter what else is going on. So be aware of that. So anytime you want to give anything to induce or reward referrals, I don't care if it's, I'm not going to give money to this doctor, but I'm going to give the doctor's wife a job. That is an inducement for a referral. If you do any deal with a referral source, a tit for tat, a quid pro quo, there's the anti-kickback statute violated. So, I have to make it clear, the anti-kickback statute is a criminal offense. It's a felony. With the Stark Law and some others, these are civil offenses, and it's pretty bad, but no one's going to jail. You're going to be fined an awful lot of money. The anti-kickback statute is a felony. It is punishable by up to 5 years in prison per offense, up to $25,000 per offense. And then, as I said before, if they bust you on any kickback, they can get you with a law called the Civil Monetary Penalties Law. And that is up to $50,000 per violation, and you have to pay back what you took from Medicare, Medicaid, whatever it was. You have to pay back three times what you quote-unquote damaged them. Not only that, you will most likely be excluded from participating in those federal health care programs, which is an awful lot of money lost until they reinstate you. Also, you can be busted under the False Claims Act, and that is a civil it's a civil violation, so no jail time, but the False Claims Act is basically a law. It started in the Civil War era. A lot of people were billing the federal government lots and lots of money and not actually delivering. So, if I made cannonballs, I might charge the government for 50,000 cannonballs and send them 25,000. No, that's a lot of waste and fraud and abuse. So they created this statute, and in the 80s they started applying it to federal health care programs. So if you make a claim for some patient treatment under Medicare, let's say, and that patient was referred illegally through some kind of scheme that you set up, well, that's a violation, and now you have to pay back, again, 3 times what you got, and $11,000 per violation. It's not pretty. So bottom line, stay away from any anti-kickback issues because it can implicate lots of other laws and lots of other penalties. So, for example, here's a case. A clinic paid 2 physicians who were very substantial referral sources. They paid them $75,000 a year to serve as, quote-unquote, co-directors and consultants for their geriatric department. But really, the docs didn't do much. They may have done a few administrative things here and there, but really, for $75 grand a year, it was next to nothing. And what did the jury find in this particular case? Found that, well, yeah, because they were being paid so much money a year and hardly doing anything for it, but also sending lots and lots of patients to this clinic, okay, that was a little quid pro quo situation. It was an unlawful referral arrangement. And the first physician got 6 years in prison, was fined $75,000, and had to pay $142,000 in restitution. The second physician, 3 years in prison, $25,000 fine. The CEO of the clinic, not just the doctors now, the CEO got 4 years in prison, $75,000 fine. The CFO, who knew what was going on, he was acquitted at first, but that acquittal was reversed. And as you can see on the slide, the attorney got off, which I'm happy to hear about. But I'll tell you, this is real stuff, and it has real teeth, and people have gotten in a lot of trouble for violating this statute. So remember, remuneration back and forth in order for a provider to, or a referral source, to send referrals. Now don't think of this just as, say, a hospital. Pharmaceutical companies who send doctors down on junkets to the Caribbean, and they say, well, it's a speaking engagement, but they're getting paid an awful lot of money, and some of them don't even bother speaking, and they pay for their families. And why would they do that? Because you're going to sell our drugs for us, basically. You're going to prescribe our particular drugs because we sent you on this nice vacation, and that is the same thing as a referral source. You are essentially, in your practice, referring patients to this drug or to this company's drug. So an intent to induce referral for services or items paid by the government health care program unless what? Unless the transaction is structured to fit within a safe harbor. Unless there's some exception to it, doing this violates anti-kickback. All right, so who is affected? Who can get in trouble for violating this? Anybody. Anybody who solicits, receives, offers, or pays. Providers like doctors, hospitals, that kind of thing. Vendors like pharmaceutical companies. Managers, administrators, remember that CEO got in trouble. Marketing personnel. Drug reps, for example. Well, let's just say I hope they don't engage in this anymore. They should know better, but for a long time, that's who got these pharma companies in trouble, and device companies, it was their reps. So the patients can. I haven't seen that too much, but it has happened. Even attorneys. Now, heaven forbid that ever happens, but anybody who sets this little arrangement up can be implicated and get in a lot of trouble. So, now again, it talks about remuneration, right? And that's a big fancy word, but it's not just money. It applies to any form of remuneration in exchange for referrals. So money, contracts. We'll give you a contract to buy your particular products. Leases. Okay, we'll lease you some space. We've got a building. Doctors, we're going to lease you some space, but you know, you better start sending patients our way. Giving free or discounted items, gifts, perks, that kind of thing. Overpayments or underpayments. In other words, things that are not fair market value. So suddenly, you know, somebody's getting paid a whole lot more than they should be. Why is that? Well, the feds are going to start looking at how many referrals have they sent. Sometimes they waive co-pays and deductibles. Sometimes they give low-interest loans, business opportunities, any kind of pat on the back or personal favors, anything like that, anything of value. Now remember here, this only applies to referrals for items or services covered by a federal health care program. Medicare, Medicaid, VA, anything like that. If it's a private situation, almost every single time you're not in trouble. It doesn't implicate the federal anti-kickback statute. It's only to save money. And I've had clients tell me, well, this is stupid. Why can't I just take a doctor out for dinner? Or why can't I just, whatever it is, why can't I just run my business the way I want to run it? And you know, I sympathize with you, and I agree to a great extent. And it is frustrating when you're just trying to do business in a very complicated and very competitive arena. But why does this only implicate federal health care programs? Well, because our tax dollars go to fund these programs, and the federal government says we don't want to waste tax dollars. We want to make sure if we're paying, we're not paying for we're not paying to line a doctor's pocket, for example, when he gives referrals to a clinic or a hospital or some other entity. We're paying for the service that the patient is getting. Also, consider this, not just waste of taxpayer money, but if you were being induced to send referrals to a particular entity, a hospital, a clinic, whatever it is, would you send the patient to the right place, the exact place that's best for that patient, or would you be more inclined to send that person to the place that you're being paid to give referrals to? Well, I think that's self-explanatory. I think you understand that. So we're looking out for patient care, the best interest of the patient, and also we're looking to not waste taxpayer dollars in federal health care programs. Whether you agree with that or not, that's the rationale behind this law. So now one thing I need to tell you, limiting financial arrangement to payments not made by Medicare, Medicaid, or other federal health care programs, that doesn't absolutely guarantee that you haven't violated anti-kickback statute. There was an advisory opinion on an arrangement that a clinic had, and they brought someone in, and they were basically inducing him to bring referrals in. We'll pay you to come in and do this particular function, but we also want you to bring referrals in, and we want you to, we'll pay you handsomely for those referrals. And it was they were only going to pay this person for referrals that weren't paid for by Medicare, Medicaid, or any other federal plan, and they thought, okay, we're covered. But the Office of Inspector General said, nope, that's exactly wrong, because there are Medicare patients and Medicaid patients coming through your doors, and this person is treating them, and this person is still in a position to refer Medicare and Medicaid patients. So just because you say, no, we're not going to pay him for those kinds of patients, there's still a threat that that would happen, and so therefore they could have gotten busted under the anti-kickback statute. So be careful and check before you just assume, oh, these aren't Medicare patients, so we're okay, we won't violate it. Now, also realize there are state anti-kickback statutes. Most states have them, and some of these statutes apply to any payer source. Doesn't matter, private insurance or anything. They want to, again, protect the patient and make sure that referrals aren't being made because of financial reasons, but what's in the best interest of the patient. Here in the state of Utah, for example, they have a kickback statute, and all you have to do is disclose that you have some kind of arrangement with this entity you're referring to. I want you to go get x-rays at this clinic, and just to let you know, they're paying me to refer you if I refer you. And so long as you disclose that, you're fine. No problem at all. Other state anti-kickback statutes aren't so lenient. Now, here's the difference between anti-kickback statute and, say, the Stark Law and other laws. In addition to it being a criminal law, there's an intent factor. There's an intent element. You have to knowingly and willfully solicit, receive, offer, etc. You got to know what you're doing. You got to mean to do it. With Stark, for example, the anti-referral law, just having a particular contract not structured the right way, there's an automatic presumption that yes, you've got some kind of improper referral arrangement going on. Yeah, but we didn't pay anything to this person. Doesn't matter. It doesn't fit the guidelines here, so therefore there's a presumption. Well, with the anti-kickback statute, you have to actually know what you're doing. You have to willfully do it. So intent is a big factor. But before you go feeling too safe, first of all, you can't say that, well, I didn't know, because ignorance of the law is not an excuse, right? That's a basic axiom in the legal world. But also to say, well, I didn't violate the anti-kickback statute because you can't prove it. I didn't admit it. There's no documentation saying I did this and let's enter in this agreement. Well, juries have inferred. There's several cases where it's just so obvious. For example, you know, a hospital hiring someone to be their medical director, paying them $50,000 a year, and they work 2 hours a week. And they really don't do much during those 2 hours. But that physician has sent, a good, 20 patients a week to that hospital. You can't find one email. You can't find one recorded conversation. You can't find one witness to say, oh, yes, we talked about this and set up this unlawful scheme. But it doesn't matter because people aren't stupid. Well, sometimes they are, but a lot of juries can infer with a reasonable standard that, yeah, this obviously is why he's getting paid this money, so therefore it's a violation. So even though there's an intent standard, it's proving intent is a pretty low threshold. It's actually difficult, very difficult to disprove that there was no intent if the facts are solid enough. All right, so now let's talk about safe harbors. Safe harbors are basically exceptions to the rule, exceptions to the anti-kickback requirements and prohibitions. What happened was the drafters of the statute had an idea of what they wanted to prohibit, and here's what we're going to make you do, and here's what we're going to prohibit you from doing. And then, as happens everywhere in life, there were situations that arose that were necessary and good, but technically they violated the black letter law of the statute. So what the Inspector General has done is taken a look at these particular things on a case-by-case basis and said, oh, actually, we really need this particular thing to happen. It's technically violating the statute, but if we get rid of this, if we prohibit this, it's going to hurt patients, it's going to hurt the whole system. So we'll make a safe harbor. So long as you satisfy this thing, it's okay to violate the anti-kickback statute. So that's what a safe harbor is. And in other words, we're not going to prosecute you. Now, you don't have to fit within a safe harbor. You don't have to be protected by a safe harbor necessarily, but if you can be, then you literally are safe. Remember, it only takes one of the purposes of an arrangement to be an inducement of referrals. Just one of the reasons you're doing something is an inducement of referrals. However, it doesn't always mean that you're going to be in violation of the law. So just remember, the closer you come to satisfying all the regulatory requirements, the safer you'll be, even if there's a little gray area there. So here are some exceptions, or what we call safe harbors. We're not going to get into them in too much detail, and you can read about them, and I can provide more resources if you'd like, but they're very straightforward. For example, you can send all the business to a particular entity that you want, so long as you're an employee of that entity. No big deal. If I'm a doctor who works at a clinic, I can stand on the street corner with a sandwich board sign around me saying, come to this clinic. And guess what? The clinic can pay me for doing that. No problem at all. A pharmaceutical company can pay a pharmaceutical rep to go out and sell their drugs, right? Well, of course they can. So if you're a bona fide employee, then it's fine to send referrals and get some kind of remuneration for those referrals. But here's the catch. You have to be a bona fide employee. A lot of people have tried to skirt this law by saying, oh, well, no, this person's a bona fide employee. And what you've done is hired the person, and the compensation scheme has been, you bring us referrals and we'll give you so much money. Well, that's not a bona fide employee arrangement. A bona fide employee is someone who comes in with a particular salary. Yes, there may be some kind of other compensation, but But basically, if you follow the IRS standards of what is a bona fide employee versus a contracted employee or some other arrangement, then you're usually just fine. You satisfy the requirements, and there's no trying to skirt this law. There are personal services contracts that qualify as or is at least fitting under a safe harbor. Sometimes leases for space and equipment, as long as you're doing that properly. You can invest in a group practice, for example, a doctor who has his own practice, or maybe a clinic, or maybe a hospital. They can actually invest in a group practice. And the investment needs to be such that it's done a certain way, and it's still above board, and it's not for the purpose only of inducing referrals. But if it's a genuine investment, then the Inspector General says that's fine. That's something that would normally violate the law, but in this case, yeah, you can do it. And there are many other types of safe harbors and categories of them. If you look down near the bottom of this slide, ambulance replenishing. That's interesting. So basically what they're saying is if you're a hospital or you're an ambulatory surgical center or something, if ambulances come and drop off patients to your particular facility, skilled nursing facility even, and you want to give them, bandages and some other supplies to restock their ambulance, obviously, what are they going to do? Well, they're going to keep bringing referrals to you. They're going to keep bringing patients to your door. So that really is a remuneration. Even if you haven't sat down ahead of time and discussed it, just the fact that you continue to give these ambulances supplies, and they're very grateful, and they continue to drop patients off at your door, OIG says that's fine. That's within a safe harbor. By the way, most ambulances, if they replenish, they usually take it when someone's back is turned. But anyway, okay, so one thing you have to understand, there is no de minimis safe harbor. Now, what does de minimis mean? It basically means, well, if I'm doing it just a little bit, if it's really negligible, I mean, maybe 1 or 2 referrals come in a year, then it should be okay, right? And no, it's not okay. If you're doing it, you're doing it. It's like being pregnant. You either are or you're not. Now, basically, if it is de minimis, usually people won't pick it up, and you may not, even if they do find out, there's usually not a lot of risk that you're going to get in trouble. But I'm not encouraging anyone to do that. I'm not saying that it's okay. What I'm saying is it's not okay, and you could still be in trouble for even those 2 referrals you get a year. All right. What about if there's no substantial risk to abuse of the program? Well, it doesn't really matter, right? You could say, well, yeah, but, you know, these patients would have come to us anyway, and, you know, we're not overcharging, and they're going to be billed by Medicare whether they go to this hospital or that hospital, so why not induce someone to bring them to our hospital? It doesn't cost Medicare any more money for them to come here and be treated than somewhere else. And that argument just won't fly with the feds. It just won't fly, so don't fall into that trap either. You really should incorporate safeguards to protect against this kind of behavior. So there's no such thing as a fair market value safe harbor. Now let me explain what that means. Basically, when you're being investigated for Stark violations or anti-kickback violations, if anyone's taking a look to see if you've done anything wrong, they're going to look at fair market value. That is the standard. So, for example, if that doctor who is being paid $50,000 a year to be your medical director of whatever, oncology, let's say, and he didn't do anything, or he put in a couple of hours a week maybe, didn't show up to meetings, And someone takes a look at that and says, is that fair market value? Well, what you have to ask is, would any hospital pay someone $50,000 to just goof around and not show up and put in 2 hours a week? And the answer is no. That's not a fair market value arrangement. And that's the standard that the feds look at. Is this particular thing of fair market value? Because if it's not, then there's something else going on here. Oh, because you're sending them referrals, so that's why they're paying you all this money that's not at market value. Okay, fine. So people often say, well, you know, this arrangement that I have is at fair market value, but it doesn't matter. Even if it's fair market value, even if that medical director is being paid you know, a fair wage for whatever he's doing. Let's say he's being paid $50,000 and he's supposed to put in 20 hours a week. And any physicians on the phone right now, you're gasping because that's way under fair market value in most cases. But okay, what if he's actually doing a good job and he's being paid a fair wage? Doesn't matter if the arrangement was done for the purpose of inducing referrals. Doesn't matter if it's fair market value. So oftentimes when you're being analyzed or audited or investigated, they will take a look at various contracts, various arrangements, and if they're fair market value, then you're good. But with anti-kickback, just because it's fair market value doesn't matter. It really doesn't matter. It's the intent to induce referrals. Okay. So, and this is what the Office of Inspector General said. When they're considering the question of fair market value, traditional or common methods of evaluating fair market value, really, it doesn't matter when it comes to the anti-kickback statute. What they're basically saying is, just because someone is willing to pay a higher price for services doesn't make it fair market value within the meaning of the anti-kickback statute. I mean, if you're dying and I've got the cure and I'm the only one who has the cure, I can charge you whatever I want. And economists would say, well, that's market economics. There's supply and demand going on here, and it's perfectly fine. So if a hospital said, okay, we're going to give this medical director $100,000 a year, and he can put in, he can come in every other week. And so long as he's sending us business, great. And you know what? A hospital will pay that because the market says it's worth it to get these patients. But the anti-kickback statute says, no, that's not fair market value. Fair market value has to be what they call an arm's length transaction. In other words, if there were no referral scheme going on here, would you still pay that much money for what the physician's doing? The answer is, of course not. So fair market value has to do with what's reasonable given the basic services that are being provided, or whatever the arrangement is, or what they're making the arrangement out to be. Not based on referrals, but an arm's length transaction for something above board. So don't fall into the trap that, well, no, it's fair market value. And I've got a consultant's evaluation saying this is fair market value. No, it better be a better standard than that. Okay, so let's talk for a second about advisory opinions. These are often very, very useful, especially when it comes to things like the anti-kickback statute. These are not safe harbors, but essentially there are, let's just say that you have a particular business and there are circumstances that technically violate the anti-kickback statute, but really you feel that it shouldn't violate it because of whatever the need is, or whatever the good thing you're doing, or the benefit to the patient, or the benefit to federal health programs, or whatever it is. And so you send in a letter asking for an advisory opinion, and you give them the facts of your individual case. And these are incredibly individual, so much so that when the OIG issues an advisory opinion, what do they say? They say, this opinion only applies to this particular individual, these particular circumstances, so you're not completely covered even if your case is similar. Now, the reality of it is, yeah, if the facts of your particular case and circumstances are very, very similar to this, you're usually covered under this advisory opinion. You're fine. You're not going to get in trouble, but it's not as rock solid as, say, a safe harbor that they've come up with. The one thing about advisory opinions, they take a long time because we're talking about the federal government. So some can take 8 months. I've seen one in 6 months. I've seen one that took a year. But if it's a very important part of your business and you want to continue to conduct business that way, then it's definitely worth it to get an advisory opinion, especially if you think you're going to get a favorable one. All right, so here's where you can look for various advisory opinions, and you can just do a term search for things that might fit your particular business and your particular needs. So some of the ones that have already been published cover things like on-call coverage arrangements, waiving co-pays and deductibles. There are certain situations where you can do that. Most you can't. Prompt pay discounts, gain sharing arrangements. And I think a lot of people on this call would be very interested. What can I do with gain sharing arrangements? What can't I do? What violates anti-kickback? How should it be structured? And we can certainly help you with any questions like that. So the OIG periodically also publishes other things like special fraud alerts, special bulletins. They'll publish an open letter. These are all just different means of getting across what they think is a violation of anti-kickback, what they think is probably fine. And again, it's very specific to individual circumstances, and even though it doesn't cover you in a guaranteed way, if your circumstances are very close, then the OIG is not going to come knocking. And you can see that listed on the website here if you want to go and check any of those out. They're for the public. And here's the website as well. So here's some examples of fraud alerts and bulletins. Offering gifts or inducements to program beneficiaries, hospital incentives to referring physicians. I mean, these are basic things that would normally violate anti-kickback, and so these are they discuss ways in which they do and do not violate, and they're very helpful, especially when you've got a specific situation that's similar. All right, so what you want to do as your particular analysis is ask the following questions. When you're looking at your organization, when your compliance officer is trying to do an internal audit, here are the questions that you have to ask yourself to see if there's any problem, even a possibility of violating the anti-kickback statute. So the first question is there remuneration to or from a potential referral source? Well, if you're asking that question, then it's almost always going to be yes, there is. Okay, so number two, do any of the parties to this arrangement make referrals for items or services covered by what? By federal healthcare programs. So don't worry too much about private payer sources. If it's Medicare, Medicaid, VA, anything like that, do they make these referrals that are covered by federal healthcare programs? And then you have to ask, is at least one purpose? It doesn't matter whether 5% of the purpose is to induce referrals. If one of the purposes of this arrangement is, then you could be in big time trouble if it's for federal healthcare programs. And then you have to ask, does the transaction fit within a safe harbor? So maybe you violated the anti-kickback statute. Maybe it's very clear that the first 3 questions have now put you in hot water, but you have to ask, okay, well, does this fit within a safe harbor? And if it does, then you're covered. Then you're absolutely fine. If it doesn't, then you have to ask, well, are there any advisory opinions, fraud alerts, or other published guidance that provide some protection? So just because you've technically violated the anti-kickback statute and there's no safe harbor that applies, there may be some other things that keep you safe. So let's apply the anti-kickback statute to just common everyday situations. Okay, so as we talk about these, ask yourself, do we have this kind of relationship? And if we do they fit the requirements of the safe harbor? Also keep in mind the Stark law. Stark and anti-kickback go hand in hand much of the time. So sometimes you can be busted for both, and you could be aware that you're violating the anti-kickback statute and not know anything about Stark. And believe me, I've had a few clients like that, which is why they came to me, and I'm glad they did. All right, so compensation paid by employer to employee. If you're paying compensation to someone for referrals, are they a bona fide employee? Are they a contracted employee? Are they someone that you just send a check to whenever they send you business? Take a look at that. Really analyze. Under the definitions that the IRS has set out, is this person a bona fide employee? And always look for fair market value. If you're paying somebody and they're bringing you referrals and you're paying them a whole lot more money than you would pay someone else in that position, that's going to be scrutinized and you may be in trouble. And what about hiring someone, like creating a position just because this person could bring me referrals? No, if you need that position filled and you would otherwise create it and fill it and give it to someone who couldn't give you referrals, that's a bona fide employee relationship. But it may not be considered that if you're creating and paying for that position just so you get the referrals. When you do agreements with independent contractors, not bona fide employees, here are the things that you want to include. Make sure these are included. It has to be a written agreement signed by the parties. You can't have a nebulous agreement. You can't have an unspoken understanding. Written agreement is what regulators will look for. And it has to be specific. You can't just say, okay, well, we're gonna hire this person to be the head of our clinic. Well, what does that mean? Well, it's going to run the clinic. No, you got to spell out specifically the basic duties of whatever the position entails. If services are provided on a periodic basis rather than full time, you got to talk about that, the specific length. Everything that you would want in a contract if you knew the person was going to try and wriggle out of it. So that's sort of the idea that you want to have in your mind when you put this together. And then usually there are some exceptions, but the term of the contract should be for 1 year. If it's not, then regulators will scrutinize that a little more. The compensation has to be set in advance, has to be consistent, again, with fair market value, and it cannot be determined in a manner that takes into account the volume or value of referrals, at least for federal program business. If you have all these elements, then you're safe. You're safe from Stark violations, and you're safe from anti-kickback, unless it's just kind of obvious that this arrangement was made to get referrals and to pay someone to get referrals. And we talked about fair market value. Here's a quick definition. The aggregate services do not exceed those that are reasonable to accomplish commercially reasonable purpose. It has to be commercially reasonable. All right, so here's an ideal, here's a case that gives us an idea of what can happen. So a hospital contracted with anesthesiologists to provide services. The hospital, though, provided free space, equipment, personnel, probably other things too. Years later, the physician services were expanded to affiliated pain clinic, but they didn't sign a new contract for that. They added services, and it wasn't set in stone, it wasn't spelled out, it wasn't set in advance and written down. And so one of the physicians brought a key tam case, which is basically he goes and complains, and the case is under his name, but basically the government takes over. And it was based on Stark and anti-kickback violations. And what happened? Well, the court found that these violations were real. Why? Simply because no written contract for the new pain clinic services was written. The compensation wasn't spelled out. Nothing that needed to be set in stone was set in stone. And the hospital was doing what? Providing free space, equipment, and personnel. So where do you think that clinic and those anesthesiologists were sending their patients for other services? Well, to the hospital. So there was a quid pro quo. There was an illegal referral arrangement, and they got in a lot of trouble. Leases, same thing, and I'll just go briefly over this. I had a client who really unknowingly made a bunch of leases, entered into leases with doctors, leased some space out for their practices within the hospital's properties, and it was way below fair market value, and got in a lot of trouble with Stark. And what happened? The hospital had to go back to the physicians and say, we need more money, please. You need to actually pay us for the past 2 years what you should have been paying us at fair market value rate. And of course, if you're a physician, do you really want to pay money you didn't agree to pay, especially in a big lump sum? No. So it was a real mess, but the physicians could have gotten in trouble for Stark violations and anti-kickback violations too, because many of those physicians did refer patients to the hospital. Why wouldn't they? They weren't getting remunerated for it, at least in their mind, but it doesn't matter because the Fed said, look, you're getting something, you're getting a lease for this space way under fair market value. There's an improper arrangement here. And there were Stark and anti-kickback violations pending, and luckily they nipped it in the bud. But a strained relationship between the doctors and the hospitals, to say the least. All right, so we'll move on to, let's see, now we won't do that. Okay, so investment in the group practice. So let's say a hospital or an individual doctor or any other business wants to invest in this practice. They think, hey, this is a thriving practice, or it could be, so I'm going to invest in it. You can do that. It's okay. And you can even be a referral source, or the practice that you are investing in could be a referral source to you. That's perfectly fine so long as it's done in a certain way, and the group practice, for example, has to qualify as an official group practice under the rules, and it can't be structured in a way that is solely for the purpose of bringing referrals in. And there are, as I say, a number of qualifying factors. So long as you meet all of them, that's a safe harbor. That's perfectly fine. You can do that. Same with ambulatory surgical centers. These are little clinics, basically, where surgeries happen, so you don't have to do it at the hospital. And so long as it's actually an ambulatory surgical center, then you can invest in them, you can send referrals to them, you can get referrals from them. If you own an ambulatory surgical center, then absolutely you can have patients from there referred to your entity and vice versa. But again, it has to be a real ambulatory surgical center. It has to qualify and fit within all the rules, and you're perfectly fine. And there are some rules for investment interests and all these things. And so long as you fall within the rules, you're not going to get in trouble. One quick one I'll talk about is recruitment. When you recruit, you recruit physicians to a particular area because you've got a shortage of physicians in those areas. You can induce that doctor to come. And, you know, you can give bonuses, you can pay back student loans, you can do whatever you want to try and get that physician there in the area. But it has to be, again, within proper guidelines for the right purposes. That physician can refer patients to you all day long, and you can give them these bonuses. You can pay for his student loans, but it has to be for the purpose of getting him, for example, in an underserved area, or other qualifying factors. Okay, there are some examples of additional safe harbors that you can talk about. If you have any questions about those, please feel free to ask me, and I can call or email you and explain. Remember, most states do have their own anti-kickback laws, so be very careful that you're covered on a state level, not just on a federal. What do you do to respond to a potential anti-kickback problem? You've gotten a letter, or maybe your compliance officer comes and says, oh, I think we might, or a doctor comes and says, hey, I have a concern that. Okay, well, don't ignore it. Don't sweep it under the rug. Deal with it. I promise you it's going to be better to deal with it than not. Is there a chance you could get away with it? Sure, but I mean, there's a chance that you won't get hit if you lie down on the road too. But you don't want to take that chance. So if anything that you've found has possibly, potentially violated any kickback statute, don't submit the claims to Medicare or Medicaid. If you have, then okay, there's a different procedure for that. You disclose that you have done so, but you've caught the problem and you are remedying it. There are, you'll have to repay CMS if that's what's happened. If there has actually been an anti-kickback violation and you've been paid, you've got to pay it back. But one thing I caution you, don't just take this into your own hands and I hate to say it, but don't trust the federal government, because their job is to enforce law and their job is to look after their program and their interests. And sometimes you get people who are just great and very understanding, but you never know who you're going to get or what kind of problems you could face. So you could just innocently say, oh, we caught this. This really was a bad thing. We fired the person and we're going to pay this back. Oh, really? Okay, great. Well, now we're charging you because you've admitted it. So it has to be done in a certain way, and we know how to do that. We're happy to help you do that. We're happy to give you guidance, even just to figure out whether there's been a violation or not. There are other acts like the False Claims Act and civil monetary penalties that you can, we talked about that earlier, you can get in trouble under those laws as well. So again, don't go admitting anything. Let's figure out a way to resolve these problems and do it the right way where you're safe. You will have to, again, not only pay back, but sometimes disclose, do what's called a self-disclosure. Maybe the feds haven't found out about it, but you did. So how do you go about doing it? Well, there's a specific process and protocol, and you've got to do it in a way that keeps you safe, right? Here's the website or for the OIG that talks about self-disclosure and how to do it and so forth. Some of the action items, and then we'll wrap up. Just take a look at your contracts. Take a look at your relationships. Take a look at your arrangements. Take a look at your marketing programs, joint ventures and partnerships. Anything that you have going, just analyze it and say, are there any arrangements that we've made that either require or have induced referrals? Okay, and then you go through those 5 questions and analyze, are we in trouble or are we safe? Just make sure that people know what the standards are, they know what they're doing. Make sure that your personnel are trained and that you have a corporate culture of compliance, that you actually want to do the right thing and that you have processes in place. If you do this, even if you get in trouble, the federal government will come in and take a look and say, well, you did have a compliance program, and you know what? Your lawyer was not your compliance officer. There are two different people involved here, so you're not trying to hide anything. Oh, and you do monthly trainings or yearly trainings. Okay, that's good. They'll take a look and see if you're taking compliance seriously. And if you are, they realize that violations sometimes happen anyway because you've got some stupid people or some dishonest people, but it's not the company itself. And so they'll go a lot easier on you if you have a compliance program in place and if you know what you're doing and if you really try to get your people on board. So additional resources you can look at. There's compliance, the compliance page at the OIG. Go on the OIG website and see all these different things available to you. And our additional resources, we have monthly seminars on various healthcare topics, various compliance and regulatory topics. Here are some of them coming up. You can go to our publications and look at various things on our website, and certainly email me anytime you have a question or a concern. There I am. I really appreciate you taking the time this lunch hour today, folks. And glad to be here at the firm, glad to be part of the team. And anything we can do for you, please let us know. And again, any questions, send them through the chat, and I'll email you back and see what we can do to help. Everyone have a great day. Take care.